special education law. This is going to be a pretty high-level overview. There are, thanks, Blake. I don't know where those lights came from. They just went on all of a sudden. So, yeah, it's pretty interesting. I don't know where I have no idea. Anyway, guys, this is going to be a pretty high-level overview of special education law. Certainly not meant to go, to the depth that maybe my special educators are more familiar with. This is just meant to be an overview for you. You will get certificates for this. I'm not exactly sure how that happens yet, but we'll make sure that you're all signed into this session. There were a few of you that might have switched sessions. So probably need you to make sure that, probably that you email Jen Magner and tell her, hey, I switched sessions and took the special education law instead. You can CC me on that so that I can verify that you did that. And if you are one of those people, can you just at least pop by and see me at the end so that I can have that little list of who might have switched sessions, just so that I can verify for you, okay? Want to make sure you get your credit. Okay, so questions that are up on the screen, you just have to, I just want you to think about, maybe jot down what you think your answers are. We'll go through them one at a time, and we'll revisit this at the end. Okay, so this is just an individual, think about it, and like I say, maybe jot your answers down and see how you do. We'll talk about this again at the end. So, your current understandings. Services a student receives is based on their disability. Would that be true or false? Again, just think it in your head or write it down. Students with a medical diagnosis will receive an IEP. True or false? Students with disabilities can be suspended the same as non-disabled peers. True or false? RTI, or MTSS, is required to determine if a student is eligible for any suspected disability. Is it required for any suspected disability? True or false? This is just a question that would require an answer other than true or false. But special education laws were instituted based on what famous court case? Do you know it? Principals can be liable for students receiving services. True or false? Okay. No luck, Blake. I don't know. Are they like emergency lights or something?
Yeah, they are.
I wonder if is there something in the office that does it?
No,
I have no idea.
Maybe there's maintenance required.
Oh, great. Okay, well, we will just deal. Thank you for checking. I appreciate it. Sorry, everybody. It's distracting for me too, but we'll persevere here. Okay, moving on. So, just a real broad overview of the law in special education. Previous discrimination had been based on exclusion, misclassification. That was a consequence of Brown versus Board of Education, that law. And that was from 1954. That was kind of the first time we had a law that dealt with any type of discrimination. Okay, Brown versus the Board of Education. And then we started to come into some other types of laws that were coming around. One, Mills versus Washington, D.C. and the Board of Education, and the Pennsylvania Association for Retarded Citizens out of the Commonwealth of Pennsylvania. And the courts ordered schools through that. This was in 1972. So realize these dates. These are not really that long ago, right? These are well within our lifetimes, right? So the courts ordered schools to provide a free, appropriate public education to all students with disabilities, to educate students with disabilities in the same schools and basically the same programs as students without disabilities, and then to put in place procedural safeguards so that students can challenge schools that don't live up to court orders. Procedural safeguards is the same thing as parent rights. That's what we call parent rights. And these decisions led to families advocating for a federal law. So this was out of Commonwealth of Pennsylvania, and it led to a federal law, which we are all more familiar with. And this was, what it is now is IDEA. But it was originally called the Education of All Handicapped Students Act, or PL 94-142. If you were in school, college, around the time that I was, which some of you not because you're not that old, this was like language that just fell right off your tongue. PL 94-142. This is the law that is the basis for federal law IDEA, which governs all of special education. So the original intent of it was to open schools to all students with disabilities and ensure that they had a chance to benefit from special education. And then the current focus is for schools to provide a free and appropriate public education to all students with disabilities. And again, this is the law that governs everything that we do in special education. It is a federal law, the Individuals with Disabilities Education Act, IDEA. So that's just kind of the very, very, very brief history. We started with a basic law around discrimination, and then it's gotten more and more specific around disabilities. So the purpose of the system is to improve student achievement. That's what it's all about. It's all about specialized instruction for students with disabilities. And that's what we're aiming to do, is to improve their achievement. We acknowledge that students' needs exist on a continuum, right? That's a big thing in special education, right? We have everything from a student with a very mild, perhaps just a speech challenge or something like that, very, very mild, all the way to the other side of the most significantly handicapped individual that you can think of, right? Who needs, full-time one-to-one care, maybe cognitively impaired and whatnot, and everything in between. We serve that entire continuum. It is a way to organize resources to make educational resources available in proportion to that student need. So each of our kids, it's based on individuals and their individual needs. IEPs for our kids, or individual education plans, are not cookie cutter. They are individualized for each student, depending on their needs, depending on their disabilities, depending on what services and what resources they do need. So the major recommendations out of IDEA is we focus on results, not on processes, what we're looking for. It's those goals, right? We set goals, we're focused on the results. We have to make sure that we guarantee FAPE. FAPE is another buzzword in the world of special education. It stands for free, appropriate, public education. Main word really being appropriate, right? It's what that, again, it goes all back to what that child needs, what they've qualified for, and what they need. And we don't say no to anyone. Pre-IDEA, pre these laws, schools didn't have to educate students with disabilities. They say, no, we cannot say no anymore. We have none, right? If we have a student within our district boundaries with any type of disability, we are required to provide them education if that's what their parents choose. Okay? No chance to say no whatsoever. We definitely embrace a model of prevention, not of failure. Special education system has been seen as that before, where you kind of have to be failing to qualify, and that is not as much where our focus is now. We look at early intervention for services for kids, especially the little ones, and we look a little bit more at prevention and and gaining them those skills so that they are more successful as they move along.
Wendy,
Yes, ma'am.
I have a little bit of a conflict that I've been going through with this idea of prevention. So we still have that question of, is this disability, they could have a disability, but it's not affecting their ability to learn and progress and in school, and they are getting benefit from general education alone. So
Yep.
where's the line there?
So this is going a little bit deeper for those of you who aren't special education, aren't in special education, but when we're looking at qualification for students with disabilities, we have to consider a couple of things. One of those is, can the student receive educational benefit from general education alone? And that's exactly how it's worded on the documents. If the answer is yes, that they can receive reasonable educational benefit from general education alone, they do not need special education services. It's as clear as that.
Or just a 504? Possible.
Or they could need a different type of a plan or something, yes. But in terms of an IEP, in terms of special education services, if that threshold isn't met, and it's one of the very first questions that we ask when we're doing eligibility, if that threshold isn't met, then they don't qualify for services. So, to clarify further, some students have a disability. It may be medically based, it may be medically diagnosed, whatever. They may have a disability, but they may not require special education services. One of the best examples of this is our students with autism. We know that autism is a huge spectrum, right? And can be very mild or very severe. There are different, just because a student has autism doesn't necessarily mean they automatically get an IEP, right? It has to be affecting their ability to access general education. And so again, that's that question that we ask. Can the child receive reasonable educational benefit from general education alone? And if the answer is yes, then we do not proceed with an IEP. If that answer is no, like they can't receive reasonable educational benefit from general education alone, what that means is then they need specialized instruction and they need the supports and services of special education.
I run into it most often with speech.
Yes. Yeah, that's very true, because sometimes we have kids who do have a speech issue, whatever that might be. They might have, something that's a problem, an R or an L or something like that they can't say correctly. The question for us in our setting is it impacting them in terms of general education? And if the answer is no, it's not impacting their education, then they don't qualify in our realm. Now, they could qualify for outside speech services. Clinical speech is very different than educational speech services. Same thing with autism. They can have a medical diagnosis of autism, but it's very different in our world of education. So getting into the weeds a little bit there, but just some things to think about and be aware of with some of the rules and some of the laws that we have to follow when it comes to qualifying students for special education. Questions on any of that? Okay. The last point on here is that our children with disabilities are general education students first. This is a big piece, right? And for my general educators in the room, I really, really, really want you to hear this, right? They're gen ed students first. And really, most of our students are in the general education classroom most of the time, right? We say 80% of the time or more. That's the majority of the students that we serve. They're in your classrooms. They are general education students first. And that's something that I think we tend to forget. We think they're special education students, so they're a special education student, right? But I want you to change that thinking. You guys that are in the general education setting are crucial to our processes. And I really, really want you to hear that too. We need you and your input. We need to know what they're doing well in your classroom and what they're struggling with. We need to know those things so that we can serve them in the right ways. Okay? All right, there were some changes to federal law IDEA in '04. One of them, LEA, is a local education authority, so that's us, are accountable for academic performance. So this is telling us that this is what we're responsible for, right? We're responsible for providing specialized instruction for our students with disabilities, and we are looking for reasonable progress for our students with disabilities. The discipline regulations were changed a bit to be more school-friendly. It became illegal to identify a child as learning disabled unless they had had scientifically based instruction from general education from highly qualified instructors. So that's that RTI MTSS piece that came in there and changed the way that we identify students with learning disabilities. See if I can explain this without overwhelming you all too much, but we used to use a system that was called the discrepancy model. And we would do two types of tests. We would do a cognitive or an IQ test to measure their ability. And then we would do an achievement test, so just like an academic test. And basically at that point, if their ability was vastly different than their achievement, and there was a certain amount of a gap, we said then that child had a learning disability. And that was really all we looked at, was those two scores. The scores are still valid and mean some things, but now what we have to do to identify a child with a learning disability is we have to make sure that they go through that MTSS system, right? They have to have had certain interventions for certain amounts of time, and we have to have adjusted that and see if that child is able to make progress and make growth in the general education curriculum without the services of special education. So, like I said, we still do a lot of those tests, and they still have validity, they still have a lot of meaning, and they're helpful to us, but we also have to have that intervention information before we can identify a child with a specific learning disability in any one of reading, writing, or math. Yes, ma'am.
Does that growth have to be, I mean, is it defined what kind of growth? I know it is defined in the law as reasonable, or I think you said it, but in the MTSS process, does it have to be growth to grade level, or just any growth?
To the best of my knowledge, it's not defined very specifically. It is defined as reasonable growth. So that's one of those areas where we as educational professionals have to really take a look at, if a child is making progress, but it's ever so slight, and it's going to continue to take forever for them to catch up to their peers, that's a different story than we put an intervention in place and all of a sudden this kid's growth chart is going like this, right? So it's one of those places where we have to use some of our own judgment and think, as a team, as that MTSS team, as to whether the progress is reasonable or not. But we are looking for growth. We certainly, if we've got a kiddo who's flatlined or even declined, anything like that, that would be a scenario where we would be looking for sure at testing for special education at that point. Good question. Any other questions right now? Okay. Special education law, honestly, is driving general education practices, right? We just heard that, right? Like, this law changed, and it changed how we do everything, right? It changed everything. So provision of services, this talks about each administrative unit. Our administrative unit is just our school district, Delta County Schools, right? That's our administrative unit. Shall provide free appropriate public education, or FAPE, it's that buzzword again, in the least restrictive environment, LRE. Those are huge buzzwords when it comes to special education law. Least restrictive environment means that we provide services for students with disabilities in the least restrictive setting. So if that least restrictive setting is the general education classroom with some support there, that's what we do. If that least restrictive setting for that child is a self-contained classroom, then that's what we do. Again, it's a continuum, and it's individually determined for each child. So least restrictive environment looks different depending on the student. Sometimes people think least restrictive environment means inclusion for everyone, 100% inclusion for everyone. That is false. Okay? Again, it is a continuum, and it is determined and decided by an IEP team as to what is most appropriate and what that least restrictive environment is for that child. Questions there? So we just talked about this, so I'm going to skip past that. Parent and child rights in special education. First of all, I want to mention, I know my special ed folks in the room know this already, but our Colorado Department of Education this year released a new version of parent rights. It used to be a whole bunch of legalese that was very challenging to read, even for those of us who are seasoned in this. It was very challenging to read. CDE put out this year basically a parent-friendly version of parent rights, and it explains things in terms that parents can understand. I was honestly very, very, very impressed. It's something that if you're interested in seeing what that looks like, you can find it on the CDE Special Education homepage. Go there and there's links to it just to see what that really looks like. And what I'm afraid has happened though is that parents have gotten to the point where they're like, don't give me that booklet because I can't understand it anyway. And they don't really realize that it's written differently now and that they can probably actually really grasp it and really understand it. So my special educators in the room, really mention that to families, that this is new, it is written differently, and we hope that they will maybe take a minute and read that. It's long, it's very long, and there's a lot in there, but again, it's written so much better than it was before, and it's not a bunch of legal gobbledygook. There are a couple of documents that we use in special education for different things. We have one that's called a prior written notice. It's the full name of it is Prior Written Notice of Special Education Action. And we use that to document any time that we have a major addition of services, a deletion of services, a major change in services, or any other strange, weird situation that comes up. And with our kids, there's lots of strange, weird things that come up that we have to explain. I was telling my special ed team earlier today that a prior written notice is one of the best ways for us as a district to ensure that we have explained things thoroughly. And it's the best kind of CYA document that we have. Many a court case have been saved by a district having a prior written notice that was sent to the family explaining a change. So maybe what we did is we ended special education services in math because the child had made enough progress to where they were at grade level or whatever. And maybe the parent came back and said, you know, you're not providing those math services anymore or whatever. And when a district has a prior written notice, it's a separate form, asks a bunch of questions, just a one-pager, but asks a bunch of different questions. The district explains the whys about that. When we have something like that, then it's pretty much a moot point. It's explained. The parents were involved in those decisions, and like I said, court cases have been won by districts by having those things. So something you may see at some point in time. We have to have consent from parents to do a couple of things. First of all, to evaluate kids, we have to have consent. We cannot evaluate for special education unless we have signed consent from a parent. And they have to know exactly what it is that we are going to evaluate. And once we do that, then we as a district have 60 days, 60 calendar days, to provide that evaluation to the parents. Okay? It starts a time clock. And that's one of the things that you'll hear if you're not a special educator. There's a lot of time clock type things. You know, this signature sets off this timeline and whatnot, and we have to know those things. Okay? So we have to have consent to evaluate. And then for an initial evaluation, the very first time a student is ever evaluated for special education, at that point we have to have a signature from the parent, which is their agreement or disagreement to provide special education services. We just have to have that signature the one time, but they have to consent to the evaluation, and then they have to consent to services. They consent to an evaluation anytime we do an evaluation, but they only consent to services one time. Okay? And at any point in any of these processes, parents have the right to say no. They can refuse an evaluation, and they can refuse services at any point in time. They can revoke services at any point in time. It doesn't have to be at a meeting. Parents can just say, I no longer want special education services for my child, and we end services and we walk away hands off. Parents always have that right. Okay. Parents always have access to records. We have parents call us every single day. Can I get a copy of my kid's IEP? Can I get a copy of my kid's evaluation? We send them all the time. Always have access to that. They also have access to due process. So if they have a complaint or an issue or anything like that, there are avenues that parents can go through through the Department of Education, through the Colorado Department of Education, to deal with those complaints and those issues. There's a state complaint process where parents can say, here's the issue, and it's a little formalized. They have to fill out certain forms, and they have to send it directly to CDE and whatever, and CDE will review that and then determine if it's something that they will move forward with investigating or not. And then the director gets a lovely phone call from the Department of Education that says you have a state complaint. It's great. It's a fun phone call, I got to tell you. I've only had a couple, but not so much fun. Anyway, so there's state complaints, and then there's further than that, they can go to something called due process, which is much more of a legal thing, which is going to involve courts and judges and things like that. We don't want to ever get to that. For the record, as a director, first of all, I've never been through a full state complaint process. And this is my 7th year as a director, 5 in a different district, and this is the end of my 2nd year here. I've never been through a full state complaint process. I've had a couple of state complaints that were dropped by the state before they ever got to anything, and I have never ever been to due process. It is my philosophy that I would much rather deal with things on the front end than wait till things get messy. And those of you who work with me pretty closely can attest to the fact that as soon as we know there's a problem with a family, then I'm going to jump in and get involved. And we're going to do whatever we can to listen to those parents, to find out what the issue is, and then to try to resolve that before things ever go legal. It is no fun to deal with that kind of stuff. Even the minor legal things that I have had to deal with take up so much time and energy, not just mine, but other people in the district, and cost us a lot of money in legal fees. So we always want to try to manage those things on the front end. And largely, knock on wood, I have been pretty successful with that. So just know that we try real hard to keep us out of court. Discipline. I'm trying to remember if there's further. Okay. Discipline for students with disabilities. We had a question on this on our little pre-test, right? How many of you think students with disabilities cannot be suspended like their general education peers? Anyone think that? Oh, you're such a
all or they can't, the same as their general.
the same as their general education peers.
It's not the same.
It's not the same. Can they be, let me ask it this way, can our students with disabilities be disciplined,
Oh, discipline.
suspended, whatever, the same as their general education peers? Can they? Yes or no?
They can.
Yeah.
It's on their disability.
So the answer is that they can be. They can be disciplined, can be suspended, can even be expelled, the same as their general education peers. There's just a process to that. There's just a process to that. And that's where the difference is. That's where the difference is. Students with disabilities can be removed, suspended, for up to 10 days in a school year. That can be consecutive or 1 day or 2 days at a time. Up to 10 days in a school year without any process happening. The law does not consider up to 10 days of removal a challenge of faith, challenge of providing that free, appropriate public education. So I usually tell my principals, you got some days to play with, use them wisely, right? Use them wisely. There are all kinds of things that happen with that. If we get to 10 days or more, we have to have what's called a manifestation determination meeting. More big words, right? It's called a manifestation determination meeting, and what that basically means is that the IEP team needs to come together and determine if the behaviors that caused the disciplinary action or the suspension were or were not caused by the student's disability. If it was not caused by the student's disability, proceed as their peers. If it is caused by their disability, the IEP team has a lot more work to do to figure out what do we change, how do we adapt, what are we not providing for this student so that they can be more successful. Let me give you an example of something that maybe wouldn't qualify as like something related to the disability. My middle school and high school folks deal with vaping, right, all the time. Vaping in the bathroom, even probably our elementary schools, right? The likelihood of a vaping incident being related to a student's disability is pretty slim, right? I'm not going to say it's not possible at all, but it's pretty slim. So we have a kid who has had repeated offenses with vaping in the bathroom. We come to 10 days, they've been suspended. We come to manifestation determination meeting. This child has a learning disability in math. Okay? Does that learning disability in math, was their vaping impacted because of that learning disability in math? Most likely not. You're going to be hard pressed to explain that, right? In that case, that student would be able to be disciplined like their general education peers. Okay? Now, flip side of that is you have a student who is identified with an emotional disability, who has tendencies that are aggressive and maybe they have a bit of a mouth on them and, you know, these kinds of things. And now they have been suspended for 10 days for things like being aggressive and cursing in class and things like that. We come to manifestation determination. That's a situation where the behaviors are because of that disability, right? That's much more closely linked, right? So that student would then not be able to be suspended any further for those types of behaviors. Again, hear me, for those types of behaviors, right? Because they are linked to that disability. And that's when the IEP team really has to kick into gear and figure out how to change things for that student. I will tell you that one of the most confusing ones is always our students with attention deficit disorder. And they're impulsive and it's real challenging. Those are situations, especially for my principals in the room, those are situations like call me, have me come to those meetings, because you have to be able to draw a direct and substantial link to the disability for it to be considered a manifestation. And parents and advocates and others like to draw a line like this to the disability and say it's caused by the disability. Those are tricky situations, and I would just say call me, and I'll come to those meetings and help you through those, because it can be pretty challenging. So that's disciplining in a nutshell. Questions about discipline stuff? Okay. So these are, this is a list of the different disability categories that we can qualify students for. We talked a little bit about autism already and that medical versus that educational eligibility criteria, right? Students can have autism and still not qualify for specialized instruction under an IEP. They may have that medical diagnosis, but they don't have an educational diagnosis. And it can actually be vice versa too. Some students only have an educational eligibility criteria met and don't have a medical. It can be either way. It can be either way. But it has to relate to that impact on their general education and that access to general education. That's what has to be there. We serve students with hearing impairments, including deafness. We serve students with serious emotional disabilities. Those are some of our real challenging kiddos. aren't they? They can be explosive, they can be super challenging behavior-wise, they can also be very internalized. They can internalize things and be very shut down. Those kiddos are super challenging also. Intellectual disability, there's, just so you know, to qualify for an intellectual disability, there are 2 criteria that need to be met. One is a cognitive score, or an IQ score, of 70 or below. The other one is what we call an adaptive score. That's sort of like the functional behavior, like daily living types of things. Are they able to take care of themselves in all sorts of different areas of their life? And those are rating scales, but that one also has to be at 70 or below for a student to qualify for an intellectual disability. So it can be challenging because sometimes we have a student whose actual intellect is very low, but they function higher. So maybe they function in the high 70s or something, 78 or 79. Those students, I tend to call them my bubble kids because they kind of live on that edge. And those kids don't qualify for an intellectual disability, which can be rough because what that accesses for students is alternate assessments and modified curriculum and things like that. So those kids who kind of live in that middle ground, even maybe those kids whose maybe their cognitive score is more like a 72 or a 73 or something, and then their adaptives are at that range too. Those kids also don't qualify for those alternate assessments or modified curriculum. And so those kids can be really challenging for you all in the general education classrooms because, again, they're super low and they're not functioning anywhere near their peers, but they don't qualify for that extra support. Those can be super challenging as well. Multiple disabilities is a category that we use for exactly that, multiple disabilities. Sometimes we have students who have a cognitive disability or an intellectual disability, and they're also hearing impaired or deaf, and they qualify for speech language impairment. So when we have some, and it always has to include intellectual disability and then others. Once we do that, we call it multiple. I will tell you that one of the main reasons why is because when we qualify students as multiply impaired or with multiple disabilities, it gives us a higher level of funding for those kids. There's variations in the funding for kids with different disabilities, and multiple disability gets us a higher level of funding. So there you go. And then other health impairment is one of those, another kind of a catch-all. A lot of times that can be maybe a medical diagnosis where that medical condition actually does impact them in the general education setting, right? This is where we find a lot of our ADHD kids. ADD and ADHD kids is under this category of other health impaired. So again, here, one of our other questions was, if you have a medical diagnosis, do you automatically qualify for an IEP? The answer is no, right? Has to have that educational impact, right? Just because you have a medical condition doesn't necessarily mean you will end up with an IEP. It has to have that educational impact. There are other avenues for students like that to get services, such as a 504 or other areas like that. But in terms of an IEP, a medical diagnosis does not automatically mean that you get an IEP.
Wendy, are you saying that speech and language could not be a standalone service then, according to this?
No, speech and language can be a standalone.
Okay.
Yeah.
Okay.
Sorry, what? Say again?
It's just not on the list.
Oh, I think there's a second page.
Okay. Okay.
There's a second page. I was like, where? Like, what did I say that made you think that? Okay, I got you.
They're not all on there.
There you go.
They're
There you go. Page 2. Page 2. Specific learning disability is another area. We look at that in reading, writing, math for specific learning disability. Speech language impairment, that is an area that can be a standalone service. A child can have just a speech IEP. Visual impairment, I will mention at this point that visual impairment doesn't just mean that a student needs glasses, right? They have a very significant, it has to be very significant visual impairment to qualify in this area. So just because a kid has glasses, even if they're Coke bottles, right? Like, it doesn't mean that they're going to qualify. We have that question a lot. Traumatic brain injury, this is another area where we serve students. So students who have been victims of an accident or something where they have had a real blow to the head and have, they have some altered states of their brain and whatnot. Those are areas where we can qualify kids too. Those are some of the most challenging and most interesting cases because many times you have students who have been completely typically developing all the way along. They have an accident and they are not the same kid that they used to be. I will tell you also, they're fascinating because I think we used to think that, brains and brain injuries and whatnot, that the brain wasn't nearly as plastic as it is. But it really is an amazing thing. And I have seen some incredible, some kids come through some incredible challenges and actually get themselves back to pretty much where they were prior to that TBI. So it's pretty interesting. We have a category for deaf blindness. This is very, very, very rare, but we do have that category also. And then we have a category called developmental delay, and that is for students who are ages 3 through 8. And I really like this category. It is kind of a catch-all. When our kids are little bitty like that, sometimes it is really hard to know what it is that is going on with them. We know that something is really different. We may or may not know what that is at this point in time, but clearly they are having trouble accessing the general curriculum, and clearly they need something, but we don't really know yet. We can put this category on them for just about anything where they're showing that they are lower, different than their peers. And that category can remain until their 9th birthday. We have to change that by then to one of these other categories. But in that time, it gives us the time to be able to really work with them and to start to try to figure out what it is that's going on. Is this a learning disability? Is this autism? Is this, what is it that's going on with this kiddo? And oftentimes by the time they have hit, I'd say even 1st or 2nd grade, we have a much better idea of what it is that's going on with them just because of that time that we've been granted. So it gives us that opportunity to say, let's just hold on a little bit and let's give ourselves the time to figure out what is going on with this kiddo before we put a more solid label, any of these other kind of labels on them. Did you have a question, Joe, or no? No. Okay, infant and toddler is another one we can't anymore. This is given to the early childhood department. Now, we used to, as a school, identify kids between birth and 3. That is in a different department now, so we don't handle that anymore. We take kids from 3 through 21, which I haven't mentioned yet. How many of you knew that we can serve kids with disabilities all the way up until age 21? Good. And And it really is, it's not categorical. If a student if they have needs that are not met by the time they are hit that 18, kind of that regular graduation, and they need more in terms of transition services to go out and about into the world and be successful, we can continue to serve them until they hit the semester in which they turn 21. So if they turn 21 in that fall semester, they finish it at semester break. If they turn 21 in the spring semester, they finish in May. If they have a summer birthday, they would have finished in May because it's not before school starts. Yes, ma'am.
If we ever did get a deaf-blind student who needs an adult with them at all times for safety and for just interpreting the world around them, I found out a couple of years ago about a program that CDE has for an intervener para. And CDE will train a para for that student, specifically in how to communicate with a deaf-blind student, because it's kind of like the Annie Sullivan to Helen Keller. They need that person to interpret the world for them and to interpret what they're saying to everybody around
Interesting.
them. Yeah.
That's probably something you're familiar with. Yes. That serves our students with
Yes, and then
visual impairments. Yes. Wonderful.
It was Maggie Crosby who taught me all about that.
Yeah.
Mantra.
Oh, she's great too. Okay, questions about the disability categories? Jeannie?
Can you just at some point speak to how I don't have my own OT?
I will speak to that right now, yes. Sorry, I did mean to hit that a minute ago. Thank you for bringing that back up. So we talked about how speech language can be a standalone service, that can be the only thing on an IEP. That is not true for our OTs. OTs, occupational therapy. We do have that as a related service, but that cannot be the only thing on an IEP. It has to be paired with something else. Okay, so just because a kid has some motor issues or whatever going on, and that might be the only thing that's going on, we're not going to evaluate that kiddo, like I said, unless there's other things going on. But in a standalone setting, OT is not a standalone. Okay. Any other questions on any of those categories? Okay. So this is just an overview of our disability categories. This is national information, and just how they fall. You can see that the largest category is specific learning disabilities, and that follows true with our district as well. Our largest category of kids with disabilities is specific learning disabilities. Followed closely by speech language impairment, and then other health impairments. And then you can see where those other categories kind of fall. They're much smaller, which I'll bet you anything, you're all looking at that and you're going, wow, because like these ones take up a lot more of our time, right? And they're the ones that are more visible and more prominent. And you would think that maybe they take up a bigger piece of that pie, but that's not the reality. They do take up a lot of our time, and they are much more intense and more complicated, but they do make up a smaller piece of that pie.
And Wendy, we are also less willing to like label a kid with an emotional disability at 5. versus- So you might have a kiddo with serious behavior issues,
Right.
but to label that child with ED at 5 is kind of a
It's a heavy label. At serious emotional disability, it's a heavy label. And that is one of those areas where I highly recommend to our teams to use that developmental delay category and see where we are when we get to like 8 years old. Because remember, we can keep that category until their 9th birthday. So it gives us some time to see. And again, you know, it's one of those areas where we might see a lot of maturity in a kiddo between 5 and 8. And then maybe they don't really actually need that heavy label anymore. Whereas if we had put that label on them at 5 years old, I find it's challenging and hard for teams to get away from a particular label once a child has been labeled with a particular disability. So if we kind of keep that open and ambiguous on that developmental delay piece, it gives us a little bit more time, gives us a little more flexibility, allows for some maturity, and then we can make that decision later. Good point. Okay, so I've touched on this, but I will say it again. Special education services and the need for an individual education plan or an IEP requires two things. It requires qualifying for a certain disability that we just went through, and that need for specialized instruction, right? You can have a qualifying educational disability and not need specialized instruction. Maybe you just need some accommodations in the classroom rather than specialized instruction. In that case, we would move more towards a 504 plan. Okay, so if you just need some accommodations and you don't need specialized instruction, we may move more towards a 504 plan. If you have a disability, you need accommodations, but you also need specialized instruction, then we would move more towards an IEP. Okay, does that make sense? Okay. Okay, so suspicion of educational disability. This is kind of where another big buzzword, another big piece of federal law IDEA comes into play, and that is what we call child find. And child find is a district's obligation to locate and then serve students with disabilities. It's simply that. We are obligated to, if we see a student who maybe their educational performance falls persistently below standards, that's where we might start thinking, maybe we have a kiddo who has a disability here. Their educational performance is unique when compared to other students in that same setting. Again, we should have bells going off in our head saying, I think we might have a kiddo here who may have a disability. And when there's no other plausible explanations to account for the child's educational performance, again, these are all areas where we should be going, we think maybe this child we might be suspecting a disability, right? And again, that's what we call child find kicks in. And we should be starting our processes to figure that out, whether that's MTSS or whatever, if we're suspecting a learning disability and we're going through the MTSS route, or whether that's a different type of disability and we're going through a different route, one way or the other. A lot of times people think child find is just about our littles, but that is not true. Child find extends across the entire continuum of students with disabilities and in the entire age frame for us of ages 3 through 21. Child find never ends for us, and it is a constant obligation for us. Okay? Questions on that? So the child could be affected by a health or a physical condition or a functional limitation that affects their educational performance. Or sometimes it's what we talked about with that TBI. There's a significant status change in the kid. Those are all things that trigger that child find, trigger us to say, hey, I think we need to do an evaluation here for special education. And then remember that a medical or a mental health diagnosis alone could be sufficient for suspecting a disability, but it's not sufficient for determining eligibility. There's those other pieces that have to happen as well, right? There has to be that educational impact for that to qualify for an IEP. So specific learning disabilities, just a little bit more on this. There are 8 areas where you can qualify for a specific learning disability. And that is in reading, basic reading skills, reading fluency, and reading comprehension. Qualify for any or all of those, and that counts. Written expression. In math, it's math calculation and math problem solving. And then there's oral expression and listening comprehension. So oral expression is being able to speak. Listening comprehension is what you hear. Those are the areas that qualify under specific learning disabilities. So often we just say reading, writing, math, right? But it's broken down further than that. And again, it can be any or all of those areas where a student qualifies. Sometimes we have students who qualify maybe only in reading or reading and writing. Sometimes we have kids who qualify only in math. We have lots of different configurations of specific learning disabilities. Okay, we talked about this a little bit already, but I will hit it again. So remember that we can remove a child with a disability who violates the Code of Student Conduct from their current placement for not more than 10 consecutive school days. And again, that can be 10 individual days or, calculated up to 10. And while I'm here, I need to mention, my principals know this because I think I've drilled this into their heads, but there is no partial day suspension in the world of special education. If you send a child home even an hour early from school, that counts as a whole day. So I always coach my principals to be cautious when using that as a discipline tactic, because again, if you send a kid home even an hour early, even 15 minutes early, that's a whole day. It's a day, and that racks up 10 really quick, right? And I also say at that point, just be thinking carefully about your numbers of days, right? Like, do we have to suspend for 3 days? Can we do 1 or 2, right? 3 racks up to 10 really quickly, right? So I would say just be judicious with that. And then remember that if we get to that 10 days, then we as a special education team have to convene that manifestation determination review, which was their behavior connected to their disability, or was it not? And that determines whether we move forward with disciplinary tactics or whether we go back to the drawing board and adjust things for a kiddo in their IEP or their behavior plan or whatever. Are there any questions on discipline? Yeah.
How does that play into effect any safety concern, either for the student themselves or staff?
Can you say a little bit more?
Yeah, so just, if the student is hurting, the safety concern, either for that staff member or they're self-inflicting on themselves, but already used up your 10 days. So then,
Right.
But if it is like an emotional impairment, then how does that work?
Sure. It's a good question, and I know we deal with that kind of thing more than we wish we did. So harm to self or others is definitely an area that is super challenging, right? And again, I know we deal with that way more than we wish we did. When it is related to the disability, that makes it even harder because we've probably used up those days and we're still having to deal with that. That is a point in time when our teams are, or should be, back to the drawing table and really adjusting those plans to make sure that we are supporting that child as best we can. It may mean that we are changing that LRE, that least restrictive environment, and we're going, more towards a them removed from their peers more often. It could be trying some different strategies, trying some different services, whatever it is, but that's a point in time. That's what should be happening at that point in time, is that team should be back at the drawing table, and really working on that plan and trying to figure out how to support that student better. You're welcome. Any other questions on that right now? Rebecca?
My question would be, how would that impact, so if it is a safety concern, well, they're not able to, if they're not getting their education, their access to their education because they're being removed so much, how does that all work out?
Yeah, so that's a tough one too. And there's a lot of tough things in special education. We do have students who, unfortunately, are so dysregulated that they really aren't getting an education at this point in time. My stance on that, as a director, is that at that point we have to take a little bit of a step back. And we have to say, okay, education isn't really happening right now, because what we have to work on is that child's behavior and their regulation and their ability to even access that curriculum, right? I mean, if you're so dysregulated, you can't access that curriculum anyway. So we're not depriving them of anything that they're already not depriving themselves of, I guess is what I'm saying. And so at that point, I have given many teams the permission to pull back from, really pushing academics and to deal with that dysregulation, to deal with that behavior, to really work on those strategies of how do we calm ourselves and how do we do that so that we can, what I would say is get at least a toehold in there. And once they're regulated for a little bit, then we can start working on that, on academics and whatnot. But it's tough. It's tough.
Parents do realize that at that point we have to address the behavior before we can even address.
You go over that in the IEP with the parents, in those meetings with the parents, you're very transparent.
Yep. And those are points when I would say I'm usually pulled in to meetings and we are talking with parents, together and whatnot. So, yeah.
And
Right?
the parents are well aware.
Yeah, by that point, they're very, very, very well aware. Just a minute. Ray, you had something?
Yeah, so for our sped kiddos who receive ISS, I typically get our sped kiddos who are in ISS, and so if we're providing their services, is it not ISS? Is it not count towards their?
So the qualifier for that is if they are receiving their services as written in their IEP, then that in-school suspension doesn't count towards those 10 days. But it has to be as it's written in their IEP.
Okay,
Make sense?
yeah.
Okay. And if you have more questions on that later, I can follow up with you. Someone over here. Yeah.
Does Mark require the team to revisit the student's plan, is what I'm hearing you say?
It does.
But can the team, or is the team encouraged to
Revisit it early?
get going?
Yes. Yes, and my special educators in the room can attest to that. I'm always like, all right, guys, we're at 4 days, we're at 5 days, whatever. Like they should be working on that ahead of time. We definitely try to attack it early. We don't, I would say we rarely, if ever, wait until that 10 days.
I didn't know if it was like, for some.
No, we can and do start working on that earlier. Yep. Good question. Other questions on that? Okay. There's that in-school suspension we talked about. There's manifestation I already talked about. All right, I'm going to hit restraint real quick, and then we're almost done. Okay, so restraint and seclusion are really, really, really tricky pieces of any law, and these are not this is not special education law. This is general education law. Is restraint and seclusion, but we tend to think of it a lot in relation to our students with disabilities. Okay, Restraint is a physical restraint, right? And what I'm going to tell you is the way I direct this as a director is that we don't restrain students unless there is a real and imminent threat to self or others. I'm going to be super clear about that. If Johnny is under the table and howling, is there a direct and substantial threat to self or others? The answer is no. Do we put our hands on that child? No. If it is too disruptive for your class to learn, I'm sorry, but you take the rest of your class out and make sure that somebody is there to deal with Johnny under the table. Okay? If Johnny is tearing apart your bulletin board, is there a substantial threat to self or others? No. So again, super sorry, but we don't put our hands on kids in those situations. If Johnny is banging his head against the wall, is there a substantial threat to self or others? Yes. At that point, can we put hands on Johnny? Yes. Okay? That could have probably taken up the entire hour and 15 minutes, that topic alone, but I wanted to hit that briefly. It is 1 minute before we are to be finished here, and I want to say, are there any other questions or anything before I let you go? There's probably a few things that I didn't quite get to, but this was pretty good.
CPI certified, correct? Put your hands on the child?
Generally, yes, unless it is a situation where there is nobody else around. Susie ran out the door and is headed straight for the highway. I don't care who it is, get her before she gets hit by a car, right? But generally, yes. Be CPI certified before you put your hands on kids. Leslie?
And I wanted to address the MTSS. Do all children have to go through MTSS?
The law is for a specific learning disability, yes. For everything else, no.
We get doctor referrals and parent requests and then
Parents can request testing at any point in time. Those usually come through me, and I work with my special education teams to figure out where we're going to go with that. All right, guys, it's 11:45. Thank you so much for your attention. I really appreciate